Thank you for joining us for another episode of Baker Hosts Ad Nauseam, a podcast series focusing on new and trending advertising issues with an emphasis on the FTC and the NAD. I'm Randall Rubenking, and you're listening to Baker Hosts. We are once again joined by Amy Mudge and Daniel Kaufman, two partners from BakerHostetler's advertising, marketing, and digital media team. Together, they have decades of advertising experience and approach advertising issues from multiple perspectives. On today's episode of Ad Nauseam, Amy and Daniel are back with special guest Randy Shaheen, a fellow partner at BakerHostetler, to discuss the final week of Lina Khan's role as chair of the Federal Trade Commission. With that, welcome to Ad Nauseam, and let's turn it over to Amy, Daniel, and Randy.
And welcome back to Ad Nauseam. We are going to do things just a little bit differently today. We've got no substantive theme. Instead, what we're going to do is talk about a pretty momentous week in FTC history, and that would be Chair Khan's final week at the helm and the literal deluge of actions that were announced during her final week as chair. And helping us to navigate this week that was is our very own partner, Randy Shaheen.
Glad to be here with both of you again, and what a fascinating and sort of jam-packed week it was. I can't remember the last time that we've seen so much coming out of the FTC.
Y'all are just underplaying this dramatically. This steady drumbeat of agency announcements. Her final week was absolutely astounding. We've never seen anything remotely like it. I mean, cases, rules, proposed rules even. You know, it certainly wasn't what we're used to seeing when there's a change of administration. All right. My heart is still a flutter and a pounding. All right. From all that went on. Before we dive in, though, what is your favorite thing you've consumed of fiction about an election?
So, look, I'm going to start. Two favorites are the TV series Veep, which I just love.
Amen. Yep.
And for movies, it would be Election with Reese Witherspoon from 20 years ago. I mean, what an amazing character we had there.
You know, both of these are fairly scandalous. I mean, they are both incredibly edgy. I'm not just trying to be edgy, but I'm going to go edgy too. It is absolutely filthy and irreverent and ridiculous, but I love the Zach Galifianakis, Will Ferrell movie, The Campaign.
And I'll go ahead and roll in here with the book.
Yeah, we knew it. We knew it, you big nerd. All right, you reader.
All the way back to 1956, a book called The Last Hurrah, which did get made into a movie, though I've not seen the movie with Spencer Tracy. But it's a fictional but really sort of true story about this old politician running for mayor of a fictional town, but really Boston, one last time, in sort of the dying throes of a political sort of machine in a big city.
It is rare that we provide book reviews or book recommendations here, so thank you, Randy.
I know. Maybe we should start going on, but I think, okay, so for this weekend, the polar vortex has left us, but it is still gosh darn cold, so I think you have some good recommendations of things to binge or things to read.
But look, before we start talking about some of the matters that were voted out in the final Chair Khan week, there were quite a lot. Let's start by talking a little bit at a high level. Like, how unusual was this, and what does this mean for the rest of 2025 and the next few years that are going to follow?
Yeah, it's interesting. I think, certainly we went back and took a look at some past transitions, right? Because after 4 years, you sort of forget like what happened last time or the time before that. And certainly the FTC doesn't just shut down, in the period between electing of a new president and the inauguration. I don't think anybody really expected that. And so, that's not what we've seen in past transitions. But what was kind of unusual here, I think, were two things. One is the amount of policy making, right? A lot of policy, and not just cases that were pending and it was time to wrap them up, but a lot of policy making initiatives, which really do seem much more forward looking and are more susceptible to the new folks coming in and just canceling it all. And it was policy making that really had partisan issues, right? The commission wasn't unanimous or fully on board in terms of those initiatives. And it really does, I think, reflect, I can remember, some transitions like when Reagan came into office, I'm that old. And, there was a change, but it was not a dramatic sort of partisan thing. But I just think we live in an era that just generally is more partisan. There's an old article, 2017. I guess this is my podcast to talk about old things, that a former FTC Chair Olhausen, wrote, where she cited some statistics. And at that point in 2017, the commission had done an amazing number of things in a completely bipartisan fashion. I think like 80 or 85%. And certainly, I think if you ran the statistics today and so in the last 2 months, it's going to be nowhere near that. So we really do seem to have moved onto an era that's more partisan, and you can see that in what we're about to talk about. Some things the Republicans voted for, some things they partially voted for and partially dissented, and so there's probably a lot of things they're going to get a second look once the Republicans are fully in control of the commission.
And yeah, let's be clear. This new administration will be focused not just on the new matters that were filed in January 2025, but they're also going to be looking at that pipeline of investigation and probably not probably, we know. We can't talk about them, but we know they have been shutting down some investigations, even ones that have been ongoing for a while that don't align with their priorities. And that just makes sense. There's only so much time in the day. There's limited resources, and any new leadership is going to want to make sure that there are resources available to do the new work that they want to focus on.
So let's kick it off and talk about sort of two major rulemaking developments. There was COPPA, the Children's Online Privacy Protection Act rule, and the earnings rule. Now, changes were made to COPPA unanimously with a 5-0 vote. Commissioner Ferguson issued a statement saying there were some changes he wanted to make in addition. But the proposed new earnings rule and changes to the business opportunity rule, those were partisan with 3-2 vote. Randy, I know you have been following the earnings issues particularly closely. Any thoughts on what the future might hold for these proposals?
Sure, and I think all of us were a little surprised that one made it across the finish line. I think that was not on our bingo cards, as they say, for something that was going to get out before Chair Khan closed up shop. Probably no time soon will either of those things be finalized. I mean, first of all, there's some question that one of the executive orders bans the publication of any new rule. And so this, as I understand it, has not yet been published in the Federal Register. So probably it can't even be published, which is the first step towards making it kind of an official proposed rule where people can provide comments. So it's going to be hung up for a long time, if not forever, in that. And then, as Daniel mentioned, the Republicans dissented. Now, it was an interesting dissent. They objected really more on the process than the substance. They didn't really give any hints as to where they might stand on substance, but they definitely on the process said, look, why are you doing this? Like, it's going to be up to us to decide if there is a rule and what it looks like. So why are you sending it out now? I mean, one thing that did happen, especially on the earnings side, that rule originally had been very broad. It was about earnings claims, not just for like multi-level marketing companies, but also a lot of gig workers, right? People who drive cars or rent lodging, right? The whole gig economy. Probably, I mean, for the most part, typically, right, Republicans don't like very broad rules. They want things more narrow. So that got narrowed in the proposed rule to just cover essentially multi-level marketing companies. Maybe that was an effort to try to attract, right, or appease Republican opposition, but we'll see.
Yeah, I thought that was really interesting. Look, we've certainly seen some FTC cases involving multi-level marketing companies that did focus on earnings claims. But there's also been quite a steady stream of non-MLM cases where the FTC did challenge earnings claims. So, I was very surprised as well. I wonder if it was just too difficult also to develop some sort of broad overarching rule that would have sort of sufficient particularity to cover just the broad range of situations where earnings claims are made.
Yeah, and I think I sort of think that's the case because I know one of the tough issues with earnings claims is what do you count as offsets? Like, what are the expenses associated with the activity that subtract from your earnings? And I think it's complicated enough with MLMs, but if you then expand it to gig, like if you're renting your apartment, like what do you count? Like, do you count like the heat and the electricity and the internet, like all the things you need anyway? Maybe it just got too complicated.
But this is definitely one. I mean, don't you think we're going to see something here? I mean, the issue of earnings and earnings claims at its core should be a bipartisan issue if there ever was such a thing. So I wouldn't think I don't know. This might not go anywhere in its current iteration, but I certainly think we can't count out earnings claim cases and maybe even business guidance or a rule.
Yeah, look, no, I agree. I think it's in the realm of possibilities. There have been a number of these cases, and we've seen statements from the Republican commissioners raising some questions about how do you substantiate earnings claims. And I don't know if they're going to go as far as saying, therefore, we should do a rule, but it does lend itself to possibility.
Rulemaking's going to be the last rule. They're going to get to rulemaking last. I think that with that we can pretty much. That is not going to be something any of these guys are going to rush to start with. But on the other big rulemaking news, yeah, Daniel, you asked COPPA. That's one where we did get our 5-0, and we don't see unanimity in a lot of places. But kids and privacy is, if we're going to get it, that's probably where it's going to appear. Although, some of the proposals that were raised for consideration in 2024 weren't adopted. Things like some limits on push notifications. But there certainly are some major changes that were adopted that companies need to pay attention to. And frankly, we will be doing a future podcast and certainly blogs that are focused on this. But in a nutshell, the changes will require opt-in consent for targeted advertising to kids. They'll require limits on retention of kids' datas and require lots of changes for COPPA safe harbors, requirements to disclose their membership and to increase transparency. And it does expand the definition of personal information expressly to include biometric identifiers.
Yeah, and I think it's important to keep in mind, like, we're going to see the Republicans a lot more comfortable with these restrictions when it comes to kids under 13, given the COPPA authority. Look at targeted advertising more broadly. They're going to be a lot less concerned about some of the issues raised under the Chair Khan era on sort of the use of data properly collected for targeted advertising purposes. But look, on kids' issues, of course.
I'm just going to guess that it will no longer be called surveillance marketing. That word, that overlay on looking at privacy generally is probably going to hit the cutting room floor.
Totally correct. But look, it also remains to be seen if Congress is going to do anything about, there have been a lot of proposals out there to address changes in order to more broadly address kid privacy issues. So perhaps teens as well. So we'll see what happens there.
Yeah, and we've talked a lot about rules so far, but really there's a lot else that went on besides just rules, including a bunch of cases that got voted out. And like I said earlier, it's not at all unusual that the commission votes out cases during this transition period. I think what was unusual here was just the sheer number that came out literally at the last minute, right? As we understand it, there was apparently a last minute non-public commission meeting that was held just before the inauguration where a whole bunch of cases all got voted out. So it was all this sort of last minute activity and some suggestion that some of these cases were a rush, not the ordinary course, that I think really makes things unusual. And then you had the Republicans' response to this kind of last minute bonanza, which is they simply decided not to show up. They didn't participate and abstained in a lot of cases from the votes, and in some cases issued scathing dissents about the process and the lack of what they felt was an appropriate transition.
Drama. But look, one of these cases, because we dive into those. One of the really interesting cases was a complaint involving an apartment rental company, and it was a case that was similar to the Invitation Homes case that was announced a few months ago. But this case is going into litigation, and it's got, along with 2 states as well, one state that has a junk fees rule that's going to be implicated here. But basically, the allegation was the company failed to allege certain mandatory fees when advertising apartment rental prices. And certainly, the amounts of rent and what's disclosed with rent is also something you'd expect would be a bipartisan focus.
Yeah, and that was one of the unanimous cases, which is really significant. Look, staff ultimately works for the chair, and they want to bring cases that the new chair is going to support. And clearly, this notion of undisclosed fees, undisclosed mandatory fees, has gained traction and is pretty bipartisan. And I think we're going to see more and more cases focusing on those kinds of issues and on any other issues where we've seen bipartisan support. Staff is looking for cases that are going to sort of be favored by the new chair, and that's the kind of stuff they'll be working for.
The rule that we did get before last week, the FTC's junk fee rule is we've talked about, is limited in scope. So do you think, Daniel, if we're going to see more of these cases, that they're going to involve collaboration with states? Because, they're probably still going to want to get money.
Yeah, look, I think we'll continue to see collaboration with states. I mean, I think they're going to pick and choose maybe a little carefully which states and on what issues. But yeah, look, the Republicans, when you look back at the Chair Joe Simon's era, aggressive enforcement, looking to get money when there were clear violations of the law. And I think we're going to continue to see that.
All right, well, let's go back to partisan bickering. It's much spicier. Daniel talked about a few cases where there was unanimity, but there are a number of cases where there was sharp partisan disagreement. One was a settlement in a privacy case that involved an auto manufacturer and the collection and selling of geolocation data without getting affirmative consent. And another one involved the issue of right to repair claims that was made against a farming equipment company. Now, the first case, the privacy case, that's settled, but it's an administrative settlement. And so there's an interesting twist there, right? Administrative settlements go out for public comment. There's a public comment period. The commission then evaluates the comments and has to adopt finally the proposed order. I can't think of a time, Daniel, maybe you know of one, where the commission, after public comment, decided not to adopt the order, but maybe if the Republicans are in charge at that point, they'll say, you know what, we're going to get rid of this order.
There's been a case or two where they've made some changes, but yeah, I can't think of any where they just killed it.
Toss the whole thing out. Yeah. So we'll see. Interesting times. And then the right to repair one, that one's in litigation. The FTC filed the case jointly with two reliably blue states, Minnesota and Illinois. So, that may have been, Amy's talking about filing with states to get money. In this case, they may have filed with the states as kind of an insurance policy, right? If the new FTC doesn't want to pursue the case or tries to settle it favorably, the states can still stay in there and pursue it.
Yeah, there was also a really interesting gaming case that was announced as well, involving Genshin Impact and the issue of loot boxes. This was also another unanimous case, but with a really interesting concurring statement by now Chair Ferguson. So they all agreed that there were COPPA violations. However, there was also a deception count and two unfairness counts that Ferguson did not support. And the FTC had alleged generally that the system for purchasing loot boxes was challenging and confusing and was misleading consumers about the amount of money that had to be paid in order to get these loot boxes, which had certain prizes. And there were also unfairness counts alleging that marketing this sort of multi-tier currency system to teens and kids was unfair.
Yeah, it was really interesting. And on that confusing currency issue, talk about spicy, Ferguson basically said it's come on, it's not that confusing. And he specifically said that the count infantilizes the American consumer beyond recognition. Booyah! This really has us wondering how he's going to view other similar cases where the FTC might be said to underestimate the abilities of the reasonable consumer acting reasonably.
I don't know. Having seen a lot of consumer surveys and consumer responses, that totally baffled me. I'm not sure you can ever overestimate how low a consumer understanding can go, but we'll see. The other count he disagreed with was the unfairness count. And now Chair Ferguson has made it clear in a number of cases that, he is not going to look at the unfairness authority broadly, right? To him, the unfairness statute or part of the statute is not something the FTC can use to just, get rid of stuff they don't like, right? The FTC's mission is not to find things that they think aren't good and ban them. That he is going to be a stickler when it comes to what makes up what you need to show to demonstrate unfairness. And that's the three-part test, right? Injury, reasonable avoidance, and a cost-benefit analysis. And here he found it lacking. And I think it's interesting to just quickly read an excerpt from his dissent. Right, he says, none of this should be taken to mean I favor the loot box scheme, right? So he's putting himself in the camp of saying, I don't particularly like this practice, but the FTC Act does not authorize us to prohibit unsavory or unseemly business practices. It forbids only unfair or deceptive acts and practices. I do not foreclose the possibility that targeting certain kinds of addictive activities to children and teenagers, such as virtual slot machines in the form of loot boxes, could violate Section 5's prohibition of unfair acts and practices, but demonstrating such a violation would require us to assemble strong evidence of substantial injury, unavoidability, and the absence of countervailing benefits to consumers or competition. So, look for him to be a pretty big stickler in terms of satisfying those elements.
So, all of this in just 1 week. And to be clear, we're not going to hit it all today, but I also did want to mention briefly the interim results that the FTC provided on its surveillance pricing study, which I think is a really interesting issue. So, the study kicked off maybe 6 months ago and was looking at how information about consumers may be used to target different prices for the same goods or services. And the FTC, in a release, noted that initial findings showed that some retailers are using personal information from people to set targeted, tailored prices for goods and services, from a person's location and demographics down to their mouse movements on a web page. Now, Ferguson and Holyoke both dissented to the release of these initial results, really objecting to the rush to release some sort of research summary that was gleaned in a few months. They noted the commission should not be releasing staff's early impressions that, quote, can be outdated with new information, because the fact gathering process is still underway. So interesting to see what happens with that study as well going forward.
Yeah, well, as we said, it was indeed quite a week. And it did give us some more learnings, detailed learnings on what to expect from Chair Ferguson over the next couple months. But I think what we really know is expect the unexpected. We saw that with Chair Khan, and we think that's going to continue with Chair Ferguson. So please stay tuned. We'll keep you up to date, but let us know what you want us to hear more from on Ad Nauseam.
Thank you, Amy, Daniel, and Randy. If you have any questions for Amy, Daniel, or Randy, their contact information is in the show notes. For more information on the latest developments in ad law, visit our Adventures in Law blog at www.adventures-in-law.com, and check out all Ad Nauseam episodes by subscribing to Baker Hosts wherever you get your podcasts. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.